In our top story this morning, the Constitutional Court is expected to deliver judgment on whether men can assume wives' surnames. The decision will be based on whether Section 26(1)(a) to (c) of the Births and Deaths Registration Act is unconstitutional insofar as it unfairly discriminates on the basis of gender by failing to afford men the right to assume the surname of women after marriage. Kani is there. She is following this for us. That's Kani Mapanga. Kani, this is an incredibly interesting story and one that I imagine a lot of people are waiting to hear, to get a bit of direction and also just out of interest. Perhaps maybe just give us a little bit more background on what we're about to hear today.
Indeed. Good morning to you, Leanne, and to the viewers at home. At 9 a.m. this morning at the Constitutional Court, we'll find out whether the Apex Court will confirm or not the declaration of invalidity against Sections 26, subsection 1AC of the Births and Deaths Registration Act. Now, if we take you back to the facts of this case, we had two very young couples that approached the Free State Division of the High Court and stated that the said section unfairly discriminates on the basis of gender, because we had two couples who wanted to assume the surname, or rather the maiden name in the marriage, as the main name for the family. So we have the van der Merwes and the Bornmans. So in the case of the van der Merwes, we saw that Jana Joran, who is the wife of Henry van der Merwe, decided that her surname would be the family name together with her husband, and that their child would also carry that particular name. However, when they approached Home Affairs for this remedy, they were limited with respect to that, because the legislation does not allow for the male spouse to assume the surname of their wife. Similarly, with the Bornmans, what you had is that Jess Donnelly Bornman assumed the name of her husband by hyphenating it. However, when her husband wanted to do the same after marriage, he was denied that right, because there is that limitation in the said section which states that the husband cannot assume the surname of their female spouse. So, of course, they challenged the constitutional validity of this particular section, stating that it infringes on their constitutional rights to equality and dignity, and, of course, places women in a legally inferior position in marriage by only stating that they have to change their surnames, but the male spouse cannot, according to law. They successfully challenged it in the Free State Division of the High Court, where it was stated that it doesn't really fit any governmental purpose, and of course it is unconstitutional because it unfairly discriminates on the basis of gender and has no justification to do so. Of course, for such a order to be given effect, you have to get that confirmation from the Constitutional Court. But at the heart of this, Leanne, is about the choice to exercise your rights. So we'll find out at 9 a.m. this morning whether men will be able to take on or assume the surnames of their wives following the Constitutional Court's determination on this issue. And I'm sure it'll be quite a much debated topic once the Constitutional Court delivers that judgment at 9 a.m. Over to you in studio.
A very interesting story, Kani. Thank you. Thank you so much for just giving us a little bit more background on what we're going to hear this morning. As we heard from Kani Mapanga, 9 o'clock is when we expect the Apex Court to deliver that one.